Gender equality. Sex-based discrimination. Sex discrimination involves treating someone, an applicant or employee, unfavorably because of that person's sex. Discrimination against an individual because of gender identity, including transgender status, or because of sexual orientation, is discrimination. The law forbids discrimination when it comes to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoff, training, fringe benefits, and any other term or condition of employment. Sex discrimination harassment. It is unlawful to harass a person because of that person's sex. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment does not have to be of a sexual nature, however, and can include offensive remarks about a person's sex. For example, it is illegal to harass a woman by making offensive comments about women in general. Both victim and the harasser can be either a woman or a man, and the victim and harasser can be the same sex. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employee decision, such as the victim being fired or demoted. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee of the employer, such as a client or customer. Sex discrimination and employment policies/practices. An employment policy or practice that applies to everyone, regardless of sex, can be illegal if it has a negative impact on the employment of people of a certain sex and is not job-related or necessary to the operation of the business. EEOC interprets and enforces Title VII's prohibition of sex discrimination as forbidding any employment discrimination based on gender identity or sexual orientation. These protections apply regardless of any contrary state or local laws. Through investigation, conciliation, and litigation of charges by individuals against private sector employers, as well as hearings and appeals for federal sector workers, the Commission has taken the position that existing sex discrimination provisions in Title VII protect lesbian, gay, bisexual, and transgender LGBT applicants and employees against employment bias. Examples of LGBT-related sex discrimination claims. Some examples of LGBT-related claims that EEOC views as unlawful sex discrimination include failing to hire an applicant because she is a transgender woman, firing an employee because he is planning or has made a gender transition, denying an employee equal access to a common restroom corresponding to the employee's gender identity, harassing an employee because of a gender transition, such as by intentionally and persistently failing to use the name and gender pronoun that corresponds to the gender identity which the employee identifies, and which the employee has communicated to management and employees, denying an employee a promotion because he is gay or straight, discriminating in terms, conditions, or privileges of employment, such as providing a lower salary to an employee because of sexual orientation, or denying spousal health insurance benefits to a female employee because her legal spouse is a woman, while providing spousal health insurance to a male employee whose legal spouse is a woman. Harassing an employee because of his or her sexual orientation, for example, by derogatory terms, sexually oriented comments, or disparaging remarks for associating with a person of the same or opposite sex. Discriminating against or harassing an employee because of his or her sexual orientation or gender identity in combination with another unlawful reason. For example, on the basis of transgender status and race, or sexual orientation and disability.